Beginning on page 95 of 161 pages in this decision. This is after Judge Young has already discussed the legal issues with this case. Inferences from the factual record. The great paradox of this case is that the government witnesses to a person are decent, credible, dedicated, nonpartisan professionals. True patriots who, in order to do their duty, have been weaponized by their highest superiors to reach foregone conclusions for most ignoble ends. There was no ideological deportation policy. It was never the Secretary's immediate intention to deport all pro-Palestinian non-citizens for that obvious First Amendment violation that could have raised a major outcry. Rather, the intent of the secretaries was more invidious, to target a few for speaking out and then use the full rigor of the Immigration and Nationality Act in ways it had never been used before, to have them publicly deported with the goal of tamping down pro-Palestinian student protest and terrorizing similarly situated non-citizen and other pro-Palestinians into silence because their views were unwelcome. The secretaries have succeeded, apparently well beyond their immediate intentions. With footnote 33 reading, one reason for this, of course, is that this gambit has been accompanied by the Trump administration's full-throated assault on the First Amendment across the board under the cover of an unconstitutionally broad definition of anti-Semitism. As it should, this court confines itself to the facts proven herein and makes no further comment. One may speculate that they acted under instructions from the White House, but speculation is not evidence, and this court does not so find. What is clear, however, is that the president may not have authorized this operation or even known about it, but once it was in play, the president wholeheartedly supported it, making many individual case-specific comments, some quite cruel, that demonstrate he had been fully briefed. Such conduct, of course, violates his sacred oath to faithfully execute the office of the President of the United States and, to the best of his ability, preserve, protect, and defend the Constitution of the United States. By ignoring the Constitution's command that the President take care that the laws be faithfully executed. The fact that the president is, for all practical purposes, totally immune from any consequences for this conduct does not relieve this court of its duty to find the facts. In the golden age of our democracy, this opinion might end here. After all, the facts prove that the president himself approves truly scandalous and unconstitutional suppression of free speech on the part of two of his senior cabinet secretaries. One would imagine that the corrective would follow as a matter of course from the appropriate authorities. Yet nothing will happen. The Department of Justice represents the president, and Congress is occupied with other weighty matters. Nor will there be any meaningful public outcry. There's an amalgam of reasons. The president in recent months has strikingly, unapologetically increased his attack on First Amendment values, balked here and there by district court orders. The issues presented here commenced last March. ICE has successfully persuaded the public that it is our principal criminal law enforcement agency. Americans have an abiding faith in our criminal justice system. After all, ultimately, they run it as jurors. The trial of all crimes, except in cases of impeachment, shall be by jury. Despite the meaningless but effective worst of the worst rhetoric, however, ICE has nothing whatsoever to do with criminal law enforcement and seeks to avoid the actual criminal courts at all cost. It is carrying a civil law mandate passed by our Congress and pressed to its furthest reach by the President. Even so, it drapes itself in the public's understanding of criminal law, though its warrants are but unreviewed orders from an ICE superior, and its immigration courts are not true courts at all, but hearings before officers who cannot challenge the legal interpretations they are given. Under the unitary president theory, they must speak with his voice. The people's presence as jurors is unthinkable. And then there's the issue of masks. This court has listened carefully to the reasons given by Öztürk's captors for masking up and has heard the same reasons advanced by the defendant, Todd Lyons, acting director of ICE. It rejects this testimony as disingenuous, squalid, and dishonorable. ICE goes masked for a single reason: to terrorize Americans into quiescence. Small wonder ICE often seems to need our respective military to guard them as they go about implementing our immigration laws. It should be noted that our troops do not ordinarily wear masks. Could you imagine a masked Marine? It is a matter of honor, and honor still matters. To us, masks are associated with cowardly desperados and the despised Ku Klux Klan. In all our history, we have never tolerated an armed, masked secret police. Carrying on in this fashion, ICE brings indelible obloquy to this administration and everyone who works in it. We cannot escape history, Lincoln rightly said. It will light us down in honor or dishonor to the latest generation. Perhaps we are afraid now to stick our necks out. If the distinguished Homeland Security Intelligence Agency can be weaponized to squelch the free speech rights of a small, hapless group of non-citizens in our midst, so too can the Federal Home Loan Mortgage Corporation and the Audits Division of the IRS and the Social Security Administration be unconstitutionally weaponized against the president's ever-growing list of enemies or opponents he hates, notwithstanding that political persecution is an anathema to our Constitution and everything for which America stands. Finally, perhaps we don't much care. After all, these plaintiffs, a group of non-citizen pro-Palestinians, are relatively small compared to the much larger interest groups who have every right vigorously to espouse the cause of the state of Israel. Palestine is far away, and its people are caught up in the horrors of a modern war with heavy ordnance, wreaking massive, indiscriminate destruction, a war that is not one of our making. Why should we care about the free speech rights of their compatriots here among us? Here's why. The United States is a great nation, not because any of us say so. It is great because we still practice our frontier tradition of selflessness for the good of us all. Strangers go out of their way to help strangers when they see a need. In times of fire, flood, and national disaster, everyone pitches in to help people we've never met, and first responders selflessly risk their lives for others. Hundreds of firefighters rushed into the Twin Towers on 9/11 without hesitation, desperate to find and save survivors. That's who we are. And on distant battlefields, our military fought and died for the men they marched among. Each day, I recognize that the brave men and women, living and dead, who have struggled in our nation's service have hallowed our constitutional freedom far above my or anyone's poor power to add or detract. The only constitutional rights upon which we can depend are those we extend to the weakest and most reviled among us. Expecting no self-correction or even outcry for the amalgam of reasons above, this court proceeds to lay the legal groundwork supporting an effective order and then sketches these special issues extant today.